Hi, I'm Elizabeth Sheargold. I'm a postdoctoral research fellow at the University of Wollongong. And in this presentation, I'll be discussing exceptions clauses and other protections for regulatory autonomy that might be included in an investment chapter of an Australia-India free trade agreement. So to begin in this presentation, I'll provide a little bit of context by broadly discussing each of India and Australia's approaches to international investment agreement reform. And then what I want to do is work through a few of the key differences that we see in the two countries' recent treaty practice. So I'll look at carve-outs or exclusions from the scope of investment agreements. I'll look at the use of general exceptions clauses and security exceptions clauses. And finally, some novel provisions that India has adopted in relation to deference and treaty interpretation. To begin with the context, as I'm sure is familiar to most of us, India has faced several prominent investor-state dispute settlement claims, particularly over the past decade. And these led to a review of India's entire investment agreement regime and what I would characterize as a relatively systematic and comparatively radical reform of its international investment agreements. So notably in 2016, India terminated nearly all of its existing bilateral investment treaties and issued a new model BIT, which contained strong protections for regulatory autonomy. Australia has faced one particularly prominent investor-state dispute settlement claim, being Philip Morris's claim in relation to Australia's tobacco plain packaging laws, in which Australia was successful at the jurisdictional phase, and the claim never actually proceeded to be heard on the merits. Australia has been engaging in IIA reform, particularly since 2011, but its approach has varied significantly. And I think this is a really important thing to understand about Australia and reform of international investment agreements, is that we don't have a model treaty, and our treaty practice, there are significant variations in the many IIAs that we've negotiated in the past decade. So there was a period where Australia rejected ISDS outright around 2010 to 2012. With a change of government, we then saw that policy altered, and then an ad hoc approach to whether or not investor-state dispute settlement would be included in new IIAs that Australia was party to. And we've seen some treaties that do contain the mechanism. In fact, most have contained investor-state dispute settlement, but some that notably do not. And most of Australia's recent international investment agreements contain what I would characterize as modest safeguards for regulatory autonomy, or moderate safeguards for regulatory autonomy. But again, the exact phrasing of these and exactly what provisions are included has varied. And I'll look at some examples of that in a moment when I talk about exceptions clauses and carve-outs. In terms of recent treaty practice, so for India, we have the model BIT of 2016, and then there's been a small handful of new agreements that have been concluded on the basis of that model, most notably treaties with Belarus and Kyrgyzstan. India's also entered into an investment agreement with Brazil, but that largely follows the Brazilian model, which is focused on investment facilitation and cooperation, and is quite different to a traditional BIT. At the time that India terminated its international investment agreements, it also issued joint interpretive notes that its treaty partners could sign up to effectively modernize or update or clarify those earlier bilateral investment treaties and bring them fairly into line with India's new model agreement. So there's also a couple of countries that signed up to those joint interpretive notes, and those also provide part of the context for India's recent treaty practice that I've looked at. In Australia's case, most of the investment agreements that have been concluded in the last decade are investment chapters within preferential trade agreements. They include some notable plurilateral agreements like the RCEP and the CPTPP, as well as several bilateral agreements, particularly with nations in the Asia-Pacific region. In 2019, Australia also concluded a BIT with Uruguay, and that replaced and effectively modernized and updated an earlier BIT that we had with Uruguay. So to turn then to some examples of the actual clauses that these countries have been including to preserve their regulatory autonomy. So some of the most notable provisions have been what I would term as carve-outs or exclusions, where we have groups of measures that are just excluded from either the scope of the treaty or the investment chapter, or excluded from investor-state dispute settlement. And these are very reactionary for both countries. They're clear reactions to the investor-state claims that the countries have faced. So in the case of India's treaty practice, the most notable example is the exclusion of tax measures. And while many countries exclude tax measures from the scope of investment chapters, or at least from certain obligations within investment chapters, India's exclusion goes well beyond this by actually making it non-justiciable. So the carve-out itself actually says that if a state asserts that a measure is a tax measure, that assertion cannot be reviewed by an arbitral tribunal, and that assertion can be made either before or after the initiation of arbitral proceedings. So it's quite a strong carve-out in that respect. India has also excluded compulsory licenses from the scope of their investment agreements, where those compulsory licenses comply with the requirements of international law, most notably the TRIPS agreement. And Australia, of course, has exclusions for tobacco control measures that we can clearly sort of tie back to the Philip Morris arbitration. So in the case of the CPTPP, this comes in the form of a denial of benefits mechanism. In some of our other bilateral agreements, this can be found as an exclusion of tobacco control measures from the scope of ISDS mechanisms. In the case of the Indonesia-Australia Comprehensive Economic Partnership, it's actually a broader carve-out which relates to public health measures and isn't as narrowly targeted on tobacco. If we look then at general exceptions clauses, both India and Australia have included GATT Article 20 style general exceptions in recent investment agreements. They're a core part of India's model BIT and its recent BIT, but Australia hasn't necessarily included them in all of its treaties. For example, there isn't a general exception in the CPTPP investment chapter, and there are notable variations in the drafting of Australia's provisions. So sometimes different paragraphs from GATT Article 20 are or aren't included. Sometimes the exception is included by reference to the WTO provisions, mutatis mutandis. Sometimes they're rewritten. There's variations of that nature. In India's case, there is inclusion of the general exceptions, but there's quite a notable difference in how the chapeau of the exception is phrased. So in GATT Article 20, the chapeau is phrased, and this is how Australia largely bases its investment agreement practice. It's phrased to prevent a party from using the exception where a measure would constitute arbitrary or unjustifiable discrimination, or where it would be a disguised restriction on international investment. So that's the WTO style language adapted to an investment context, and that's what's used in the Australian exceptions clauses. India has adopted a more novel formulation, which limits the scope of the exception to measures of general applicability applied on a non-discriminatory basis. So it's a simpler formulation and arguably is a lower bar. The GATT Article 20 chapeau, as I'm sure people are familiar, is considered to be a sort of safeguard against abuse of the exceptions, and arguably India's formulation here might be a less strong safeguard against abuse, or might allow the exception to be invoked a little bit more easily. Although it still does refer to measures being applied on a non-discriminatory basis. So there is still a safeguard there against whether or not the measures have unjustifiable discrimination in them. India also in its general exceptions only uses the nexus requirement of necessary. So a measure must be necessary for its purpose, such as the protection of public health. Whereas Australia uses necessary as a nexus requirement in relation to many of the subparagraphs of its general exceptions, but sometimes does use other nexus requirements, such as relating to in relation to exhaustible natural resources, which is in line with the GATT Article 20 approach. When it comes to security exceptions, this is a notable aspect of India's BIT practice, where not only do they include strong security exceptions which use self-judging language like any measure a state considers necessary. That's quite common for many countries. Where India takes it a step further is to have annexes on these agreements that deem the use of the security exception as non-justiciable. And so I've put the text of one of these annexes up on the slides, and you can see it's quite strongly worded that if any state invokes this, whether or not it occurs before or after the commencement of arbitral proceedings, that invocation of the security exception is non-justiciable, and no arbitral tribunal can review that issue, can review any decision, to use the security exception. So this is quite strongly worded, clearly on the part of India. And there have been cases in which India has sought to rely on a security exception, at least in part, such as the Devas arbitrations relating to the allocation of mobile phone spectrum. Finally, what I wanted to look at in this presentation is an interesting example from India's recent treaty practice, which is a novel provision that goes alongside the clauses on burden of proof and governing law in the ISDS mechanism, which states that The treaty shall be interpreted in the context of the high level of deference that international law accords to states with regard to their development and implementation of domestic policies. Now, this doesn't in itself create any kind of sort of defense or absolute sort of exception that could be invoked in regard to a specific measure, but I think it is worth noting as part of the tone of the Indian BIT overall, and that when India sought to rebalance the sort of investor protections versus regulatory autonomy, this is an example, I think, of another way in which India has tried to strengthen the position of the host state in an ISDS claim by directing this sort of interpretive approach that would give extra deference to a host state. Australia's treaty practice doesn't contain anything similar to that. It only contains the kind of standard clauses that you find in many nations' investment agreements that reiterate or clarify that the burden of proof falls on the claimant, which is, stating no more than is typically obvious in most adjudicative systems. So these are all differences that we can see in India and Australia's recent treaty practice. I think it's important to note when we think about the possibility of an investment chapter in an Australia-India free trade agreement, that Australia has had a very variable approach to the drafting of its investment agreements. There are investment agreements that do not contain some common substantive obligations, like the Australia-China Free Trade Agreement has a very narrow range of substantive obligations in it, in part because it was meant to be followed up with further negotiations in the future, which to date haven't occurred. The Australia-Uruguay BIT, the recent 2019 BIT, doesn't contain a national treatment obligation. Some of our BIAs do contain general exceptions, some don't. And there are notable drafting differences in some of the substantive obligations like fair and equitable treatment or in the drafting of exceptions clauses. So Australia's approach isn't clearly based on one model. There's been a lot of flexibility and a willingness to compromise on different points depending on who different treaty parties are and what they're willing to sign up to. So I think there's definitely potential for compromise here, particularly when we look at Australia's general willingness to do that, depending upon what else is on offer in the negotiations. However, when we look at Australia's treaty practice, it is in general more moderate in the way in which it sought to protect regulatory autonomy when compared to India's approach. And I think there will definitely be elements of India's recent treaty practice that could prove sticking points in negotiation, particularly the use of non-justiciable provisions like the security exception and the carve-out for tax measures. I imagine, given Australia's general approach to security exceptions, which is that they are still reviewable, at least on a good faith basis in most cases, I imagine that Australia would have some reticence perhaps about signing up to an agreement which included non-justiciable exceptions or carve-outs. Finally, and this is something I hope we'll be discussing in the panel with my colleagues at our conference, the design of any ISDS mechanism will of course have a significant impact on the substance of the investment chapter. So the extent to which there are things like requirements for exhaustion of local remedies or alternative dispute resolution processes would definitely have an impact on what Australia was willing to agree to, I think, in terms of the substance of the investment chapter. So thank you very much for listening, and I look forward to our discussion next week.